I'm Jocelynne Scutt, and I'm welcoming you to our CEDAW, that's the Convention on the Elimination of All Forms of Discrimination Against Women, our CEDAW hearings. We're holding these hearings with a series of witnesses in order to draw up a submission, a report and a submission that will go to the CEDAW Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW Committee, which sits in Geneva and which regularly conducts reviews of the countries who are the signatories to CEDAW, who have ratified CEDAW, and we in Australia have signed the optional protocol to CEDAW. We signed CEDAW in 1980. We ratified CEDAW in 1983, and we signed the optional protocol in 2009. The latter means that if a case goes through the courts here in Australia and it goes through the whole procedure, a woman has a claim in relation to a breach of CEDAW in relation to women's rights, then if she's not satisfied with the outcome under the Australian legal system, our Australian government, Australia, has said that she can go to the committee sitting in Geneva in order to get a determination from them. That won't change the law in Australia, but it will mean that the government is under notice that what has happened is wrong and that the women's rights should be properly affirmed by a change consistent with the determination of CEDAW. I want to say that we're sitting here today. There are 5 of us on the panel. I'm sitting together with Mary Kerr, with Dr. Helen Pringle, with Kerry Heubel, and our 5th judge is Bashi Kumar, who unfortunately can't be with us today. She is an example of being a mother in the current society because the children are sufficiently young to go to kindergarten or preschool. And as we all know, particularly if we're women, that what that means is that children bring home the colds, the flu, the allergies from kindergarten or preschool. It's a consequence of being children. And Bashi Kumar is not with us because she is now suffering the effects of being a mother, a caring mother to the children who have brought something home from kindergarten. But she will be with us in spirit, and she'll be participating as she can from home. I would like to commence simply by saying, as the American poet Maya Angelou said, each time a woman stands up for herself, she stands up for all women. I want to refer briefly to 1977. In 1977, the Women's Electoral Lobby drew up the draft bill on rape and other sexual offences. And a principal provision of that draft bill was that when rape laws are changed, or any law is changed, at least as it impacts on women, it should contain the statute a compulsory provision that compulsorily commits judges who will be practicing in the field, who will be presiding in that field, to compulsory education about the law and about the legal changes. Unless there is that education compulsorily, any new law or law reform is bound not to operate in the way it was intended. Now, that was 1977, and sadly, that provision did not come into law. But in 2021, some 50 years later, the Canadian Parliament passed such a provision in relation to their own rape law changes. So that took 50 years. I'm saying to you that we must make sure that the next 50 years we are not waiting for changes to come about that is essential to women's rights. And our witnesses to this CEDAW hearing will tell us what has happened in the past in their field and or what is happening now and what we should be demanding. And I'd like to conclude this introduction before I hand over to Mary Kerr to introduce herself. And then Kerry Heubel will introduce herself. And then Dr. Helen Pringle will introduce herself and speak to us about CEDAW. I'd like to say this, that all of us as women must stand up for ourselves and stand up for all women. But what we are doing as women are dancing through shards of glass. Dancing. She danced as a child, feeling pretty, toes twinkling, dancing through the days, delicious in the feeling, her body supple, new, into a world of wonder. Through she went, those twinkling toes on pretty feet tripping, into arms and hands and tongue and teeth and torture, through into another world of grown-up gluttony and greed, robbing her of dancing feet, twinkling, taking, taken, of memories pure, of body moving, gracefully growing, taken, through into a growth sought to be stunted by hands and arms and tongue and teeth, torture by an ogre in human form, failing her, her dignity, her own body taken from her, transported into terror-filled, filling her body, filling her mind, filling her hands and feet and toes and person, whole from wholeness removed, taking from her childhood, gone in the grip of arms and hands and tongue and teeth and torture, tortured mind. Shards. Who is this? Who did this? He did this, took from her. Herself, her essence, her beauty furled, in gentle comfort torn. Torn, taken, tormented, tortured, stricken. Taking, robbed and splintered. Mind, body, spirit split. Shards of sharpness shaping childhood. Making wretched, torment. Of glass, was then, yet now, through time and tenderness and soul reflection, taking care of self, though not whole, making whole, recovering by uncovering the child in her, denied by hands, yet her hands engaged now, visionary, inventive, imaginative, inspired, created in reversing adversity, dancing through glass shards, now healing, bringing forward, remaking whole through glass healing. That's why we as women are working together in the women's movement. It's often said that we stand on the shoulders of women before us, and that, of course, is true. Yet we also hold our hands out together, our hands together, making that difference that makes whole through glass healing. I now hand over to Mary Kerr to introduce herself and to speak to us in terms of her wishes, desires. Mary.
Thank you. Good morning. My name is Mary Kerr. First, I'd like to acknowledge that we have gathered on Gadigal country and pay our respects to the elders and traditional owners of this land. I'm from Darwin, which is located in the Northern Territory. I spent the majority of my childhood growing up in the NT. My mother is an Aboriginal woman from the Daly River region, and her traditional homeland is Woody Deer, and that's southwest inland from Daly River. I completed high school in New South Wales, and then I returned to the NT shortly after that, where I then actually joined the Northern Territory Police Force. I've been a police officer coming on to 6 years now. As a presiding judge on this panel, I'm honoured to be a part of the discussions being held here today and over the next 3 days. And being asked to be on CEDAW is actually an honour for me, and understanding the objectives that that are being held today and in the future. Obviously understanding that the aim of CEDAW is to have equal rights for women and eliminating discrimination. Unfortunately, many women in the NT are not aware of CEDAW, and I hope during these next 3 days I can take that back to people and express and show them that this is something that women need to be aware of. I'm passionate about a lot of things, especially Aboriginal rights, especially for women and disabilities affecting women. As I'm one of 6 siblings, my younger sister has a severe condition, and that has affected my family, but also her livelihood. From the CEDAW hearings today, I hope to learn more from the women that are going to be presenting and provide my personal and professional experiences. So I'd like to say thank you, and thank you to Jocelynne for having me.
Thanks so much, Mary Kerr. And now we'll hand over to Kerry Heubel. Kerry.
Well, I'd like to also make a welcome to country and acknowledge the elders past and present and future, and just like to say just a little bit about myself. I heard my mother once made a comment to me that it was very, very important to always let a man win at tennis. And of course, that throws up all kinds of smiles among us all, because we all know that that is just unacceptable for women. But that's how my mother's generation thought about relationships and herself in the world, and how she wanted me, because I would never get a man if I didn't learn to put him on a pedestal. So I rebelled, of course, who wouldn't have at the time. So I, at about the age of 26, I joined the Women's Electoral Lobby, and as a result, I was involved with researching the role of single parents throughout the New South Wales. It was only a local, it wasn't Australia-wide, it was statewide. And I discovered that in the most affluent area of Sydney, 1 in 4 women were single parents living in poverty. And that is in the most affluent area of Sydney, Mossman. This, of course, spurred me. I was not a parent at the time. It spurred me to want to get involved and do more for the women's, what I saw as the women's cause in those days, without realising it was subsequently overt discrimination. I went on from the Women's Electoral Lobby to, just lost my place, I'm so sorry. One morning when I was sick in bed, whilst I was a member of the Women's Electoral Lobby, I turned on the radio, and the radio, on came early morning radio, knitting, recipes, advice to mothers. And I sat there appalled, because in the evening radio, there were really interesting programs, clearly geared to men. So I contacted the ABC and asked them if I could talk to them about ways of changing morning radio for women. And we had an agreement that I would supply speakers from the Women's Electoral Lobby and other places to offer alternative views of things that affected women. And we had issues like, I am a grazier, I am a farmer, things on Wendy McCarthy from I can't think of the word, family planning. All came on, the switchboards were jammed for days and days, and the ABC finally realised that what they had been showing or listening, providing for listening, was trivial, and morning radio changed. I went on with the Women's Electoral Lobby to be involved in things like family law reform. 3 of us, Di Graham and Jocelynne, Scutt and myself, provided submissions to the family law court at the time to change, and to the government to change the law to include, as Jocelynne put in, just a minute ago, to say that judges needed to take into consideration women's role, both as mothers and as parents and as working women. We then went on to work on the sexual offences law reform, and the same issues applied, where we needed the courts to stop insisting that women were on trial instead of the men. I joined the Women's Advisory Council as the executive officer under the state government at the time, which was Neville Wran, and organised things like country visits for the Women's Advisory Council to go and find out what women's issues were in the country. I was actually the designated officer to take submissions from Aboriginal women. And we travelled around the state and learned how people were saying things about a woman must have a man look after her. And these wonderful country women were saying, I work on the farm, I do the same as the men, and I do all the domestic work, and I help the kids, and I feed everybody, including the domestic workers. This was a revelation for us in the city. None of us knew, but we made it public, and we brought the government's attention to what was going on as well. I also went travelling with the New South Wales Anti-Discrimination Board, and once again was the designated Aboriginal Women's Officer with Bobby Sykes to find out how discrimination affected women in the country. And it was a wonderful eye-opener, and I met all these wonderful women who not only educated me, but educated the Premier and the New South Wales Women's Advisory Council as well. I wrote submissions with the Women's Advisory Council on a variety of issues, including the inquiry into SBS. I wrote the submission on behalf of Joyce Clegg that set up the Aboriginal Women's Unit, of the Aboriginal unit it was, but Pat O'Shane went in as the director. And I wrote that submission. And also we had a look at the role of women in clubs. They were always associate members and never full members, and therefore not entitled to the value of full club membership. And that was, in many particularly country areas, that was the major form of escape, of relief, of entertainment for many women who didn't join the Country Women's Association. I did a submission, I worked on a submission in Sydney that was an extension of the submission of inquiry into prostitution in New South Wales that had been done in South Australia a few years before. And I took the submissions personally. I wrote them down, I solicited the submissions and elicited the information from the prostitutes, who were really wonderfully warm people who simply had no way of letting anybody know what was happening to them. And this was the first time in New South Wales that people were able to know where the prostitutes came from, why they were doing prostitution. Very few of them did it by choice. And this submission was presented to the New South Wales Premier. I moved on to become a teacher, and during my teaching times I taught adults, and I taught international students mostly, or migrants or refugees, or all end. And it was during this time I became aware of the role of the wives of migrants or would-be migrants, or the wives of male male officers or male students or employees of universities. And the women needed to learn the English, the men had the jobs, and many were experiencing violence.
Good. If we could just stop there, Kerry, because the first witness that we're having on, Leonie Maguire, will be speaking exactly on that issue.
Wonderful.
And then we can ask her questions where we can develop some of these ideas and issues. So thanks so much, Kerry Heubel, and now over to Helen, Dr. Helen Pringle.
I'm sure you're waiting very much to hear Leonie. I just wanted to I'm Helen Pringle. I'm an associate professor at the University of New South Wales now, and I teach and research here, and I research and teach in the area of women's rights, human rights, and questions about justice and public policy. I'm also the coordinator and the co-coordinator and co-founder of the Nordic Model Information Network, which is a global network of researchers on the prostitution system. I just wanted very briefly to talk about, perhaps some more about me will come out during the time, but it doesn't matter. What I wanted to just put this in the context of is very briefly the promise of CEDAW. So CEDAW is, we tend to think of bills of rights and statements of rights as lists of rights that we go through, but CEDAW is more than that. It's a vision. It's a vision of a world in which women and men have substantive equality. And it's a vision which is meant to be reflected in domestic laws, Australian laws, and is in part reflected in the Sex Discrimination Act. The vision, if I could just briefly actually quote from CEDAW, the vision is about the elimination of discrimination so that we could live together in relations of equality and mutuality. CEDAW aims to eliminate any distinction, I put the emphasis on any distinction, exclusion or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment or exercise by women, irrespective of their marital status. And as Kerry was talking about, sorry, that's not in the statement in CEDAW, irrespective of their marital status on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. Again, I've added the emphasis there. So the width of the term discrimination as used in CEDAW reflects the vision of substantive equality between men and women. It's not qualified by any considerations about practicability or limited by references to equality of opportunity. Unfortunately, in the Sex Discrimination Act in Australia, there continues to be explicit reservations made right at the beginning of the Sex Discrimination Act, which qualifies this vision of substantive equality by considerations of references to practicability or equality or references to equality of opportunity. So, for example, the Sex Discrimination Act talks about its objects, the desirability of putting its objects in place so far as is possible, or as far as is practicable in that way. Unlike, for example, the Racial Discrimination Act, which at the Commonwealth, which is the archetype of Commonwealth anti-discrimination legislation, which simply talks about, which doesn't make any qualifications about practicability. We women are, and our sex rights are apparently a little bit more difficult than that they're more an aspiration rather than something in reality. So the use of phrases such as so far as is possible or so far as is practical constrains the force of CEDAW in Australia, because as it comes through the Sex Discrimination Act, it transforms the vision of CEDAW instead of to a vision and putting in place straight away equal relations between people. It confines what CEDAW is in Australia to a limited aspiration, a level of limited aspiration, rather than requiring state commitment and action towards substantive equality between men and women. Now, so I think it's important to realise how CEDAW comes into Australia and how the promise of it has been diluted in Australia. The other thing I suppose that to point out about CEDAW is that it has what you might popularly call a join the dots approach. It's not limited to this area or that area. It's not limited to a set of discrete demands. All these things are joined together. So when we in the era of Me Too, sometimes people think, oh, that's about harassment or this and that's. They don't necessarily tie it to questions about the prostitution system. They don't necessarily tie it to join the dots between forms of violence between women and forms of inequality between men and women in that way. So I think as we go through, just to always recall that even though we've got discrete speakers, that we need to join the dots in this vision of substantive equality.
Thank you. Thanks so much, Helen. And we acknowledge, as has been acknowledged, that we sit here on Gadigal country and we honour the commitment of the First Nations people of this country that ensured that the land was preserved and conserved so that we could sit here today.